The notion that many people, even many philosophers, have about Kant's ethics, it's based not on anything Kant ever said or wrote, but it's drawn from a remark made late in Kant's career by a prominent French writer and philosopher who was recruited to oppose Kant in a controversy about the morality of lying. In the journal Frankreich, Benjamin Constant wrote the following: "The moral principle it is a duty to tell the truth would, if taken unconditionally and singly, make any society impossible. We have proof of this in the very direct consequences drawn from this principle by a German philosopher who goes so far as to maintain that it would be a crime to lie to a murderer who has asked us whether a friend of ours whom he is pursuing has taken refuge in our house." End of quote. A note to this passage by Carl Friedrich Kramer, the editor of Frankreich, informs the reader that Kant was the philosopher Constant meant. Kant never, in fact, said this about Kant's example of the murderer at the door. In his lectures, Kant even cited cases where you would be justified in speaking falsely to someone, either to achieve some good or to avoid some evil, or else simply because it was up to the person to whom you were speaking to decide whether to believe you or not. In his brief late essay on a supposed right to lie from philanthropy in 1798, Kant did dispute a principle Constant had put forward, namely, that you have a right to lie to someone whenever that person has no right to the truth from you. Kant did not totally reject this principle, but he did note an exception to it, citing a kind of case in which, even though the person had no right to the truth from you, even though it might harm him or some third person for you to tell him the truth, you would nevertheless violate a duty of right if you lied to him. I will return later to this disagreement between Constant and Kant, but first I want to look at the position apparently attributed to Kant by Constant and often attributed to him by others based on the Right to Lie essay. I want to explain why that interpretation of Kant is wildly mistaken, yet it badly misleads many, perhaps most philosophers and students of Kant down to the present day. The position attributed to Kant by Constant and many others is what some call absolute deontology. This position holds that morality consists, or at least includes, a set of strict duties, strict do's and don'ts, action kinds that are absolutely required or absolutely forbidden, whatever the consequences. Lying, in the sense of speaking falsely, is then thought to be one of the strict don'ts, so that, as Constant puts it, it is a moral duty to tell the truth, and this duty holds absolutely, without exception, even if by speaking the truth to a murderer, you enable him to murder your friend. This is the insanely extreme position often ascribed to Kant. Why might someone think Kant holds that position? One thought that seems to appeal to consequentialist moral philosophers is that Kant holds this extreme position simply because he is not one of them. But he's a diametrical opponent. They think he does not accept the idea that moral right and wrong depend even indirectly on either the actual or the intended consequences of actions. Based on the first formula of the moral law that Kant's put forward in the groundwork, many think that the rightness or wrongness of an action depends exclusively on whether the maxim of the action can be willed to be a universal law. If it can be, then it is permissible. and if it can't be, it is impermissible, no matter the consequences. Consequentialists then infer that the formula of universal law does identify certain action kinds by ways of their maxims that are required by a categorical imperative, an ought principle that is not based on any end to be achieved and any bad consequence to be avoided. They conclude from this that Kant holds the insane position that telling the truth is absolutely required by such an imperative, and holds that any speaking falsely is absolutely forbidden, even to the murderer at the door. One kind of response to this way of reading Kant has been offered by Christine Korsgaard and Helga Varden, both of whom argue that if we apply the formula of universal law to the case of the murderer at the door, that would result not in our being required to tell the murderer where his intended victim is hiding, but would even require us to keep this information from him. I think their argument may be successful, assuming their background assumptions, which, however, get Kant badly wrong in many ways. Nevertheless, I'm sure their conclusions would be those of Kant's ethics as applied to Constant's example, as this example is usually understood. My objection to the absolute deontology reading of Kant is, however, quite different and more fundamental. I think if we read the groundwork with care, you can see that Kant's use of the formula of universal law is much more restricted than it is usually thought by Kant's critics, or even by many of his self-appointed followers, including Korsgaard and Varden. Kant never uses the universalizability of a maxim as a general test of moral permissibility, and he never derives any positive duty from it. He uses it, as he says in both the first and second sections of the groundwork, only as a canon or standard of judgment in the application of duties. Judgment for Kant is the application of a concept or principle to our particular case. Regarding the moral principles or duty concepts, Kant is worried that our judgment can be distorted by self-preference, adapting duties to our needs and wishes. We can, however, correct this if we see things from the universal standpoint of reason. Kant says that in doing this, a moral agent does not think the moral formula of universal law abstractly, so it is not used explicitly in a piece of discursive reasoning. To put things starkly and bluntly, it is a basic misunderstanding of Kant's ethics to think that it consists in the silly procedure of going around formulating maxims for all your actions and asking whether they can be universalized. Since universalizability is not to be used explicitly as a test or criterion, it is also a fortiori, not a test of permissibility that could be defeated by counterexamples in cases where it does not get the intuitively right result. The long tradition of arguing back and forth about whether universalizability is a useful moral criterion is totally irrelevant to Kant's ethics, whatever philosophical interests such disputes might have entirely apart from Kant. Kant's theory of duties is actually grounded not on the first formula of the categorical imperative, the formula of universal law, but on his second, humanity or rational nature as an end in itself. The groundwork states the four duties used in his example only in relation to the second formula. It tells us that moral duties specify how we ought to act for the sake of persons, ourselves, and others. The second formula is not a criterion or test of any sort. It is simply a ground or reason. Kant presents a general theory of duties grounded on it in the doctrine of virtue. There it applies not only to actions or maxims, but also to attitudes, feelings, and desires. It identifies what is virtuous, vicious, dutiful, contrary to duty, or morally meritorious. According to the doctrine of virtue, the following are forbidden: suicide, self-mutilation, unchastity, gluttony, lying, avarice, servility, envy, ingratitude, malice, arrogance, defamation, ridicule, and the giving and taking of scandal. But circumstances or consequences may determine to which actions these duties apply. All the following are obligatory: self-preservation, chastity, truthfulness, self-respect, respect for others. Again, whether an action is or are not obligatory in any of these ways may depend on circumstances and consequences. And all the following are meritorious: self-perfection, self-knowledge, beneficence, gratitude, sympathy. Merit possessed by a meritorious action may depend directly on its consequences. An action more beneficial is more meritorious, just as a wrong action is, which is more harmful, is more blameworthy. The concepts of these duties have moral judgments: obligatory, contrary to duty, meritorious, built into their very meaning. These judgments hold without exception wherever the concepts apply. But where they apply, it's a matter of judgment about particular circumstances, including the consequences of different courses of action. Kant's ethics is in this respect rather like Aristotle's. For him, all courageous, temperate, or generous actions are good, while all cowardly or rash, all intemperate or insensible actions, all mean or prodigal actions are bad. And it is good judgment which applies, or phrases that decides when these concepts apply. The consequences of an action can play a role in judging where duty concepts apply and where they don't. Judgment is a capacity developed through experience and through thinking about hard or problematic cases, some of which Kant considers in the casuistical questions he weaves into the discussions of the doctrine of virtue. For example, for Kant, speaking falsely, the Latin is falsiloquium, is a different concept from that of a lie, lüge, mendatium, which is a falsiloquium dolosum, a wrongful falsehood. But not every falsiloquium is a lie. Kant obviously does not think that you wrong someone whenever you speak falsely to them. Here's a quotation from the Metaphysics of Morals that makes that point. We may rightfully do to others anything that does not diminish what is theirs, as long as they do not want to accept it, such things as communicating his thoughts to them, telling them or promising them something, whether what he says is true and sincere or untrue and insincere. Veriloquium aut falsiloquium. For it is entirely up to them whether they want to believe him or not. End of quote. In his lectures, Kant also says the following: I can commit a falsiloquium whenever my intent is to hide my intentions, and the other can also presume that I shall do so, since it is his own purpose to make a wrongful use of the truth. If an enemy, for example, takes me by the throat and demands where my money is kept, I can hide the information here, since he means to misuse the truth. That is still no mendatium. End of quote. Here's another quote from the Kant-Lectures. The lie finds seeming defense in the case of those told in jest or out of politeness or under necessity. A moral casuistic would be very useful and would be undertaking much to the sharpening of our judgment if the limits were determined how far we may be authorized to conceal the truth without detriment to morality. End of quote. In his discussion of the ethical prohibition on lying, Kant also says this, quote, no intentional untruth in the expression of one's thoughts can refuse the harsh name of a lie, end of quote. That statement is sometimes cited as proof that Kant holds the insanely extreme position that every falsehood is a lie and therefore absolutely forbidden. However, Kant is still not saying that we may never speak falsely. Concealing confidential information from someone not entitled to it, or speaking falsely to protect yourself or another from harm, is not simply intentional untruth in the expression of one's thoughts. This passage needs to be understood in the context of Kant's theory of conflicting obligating reasons, rationes obligandi. Kant denies that two obligations can conflict. If we mean by this that one valid obligation might cancel another valid obligation. But Kant never denies that there could be cases where one valid obligation collides with another in such a way that they might make it impossible for you to act without violating one of them. And he positively affirms that there can be conflicts between the grounds of two valid obligation reasons, rationes obligandi. In such cases, what you should do is governed by the principle fortior obligandi ratio vincit. The stronger obligating reason prevails. Which of the obligating reasons is stronger is to be decided by good judgment. For example, as we've already seen, Kant thinks there might be cases in which the obligating reason do not lie might be overridden by the obligating reason don't insult, don't harm, defend yourself or another from unjust harm. But even in these cases, Kant says the obligating reason remains, even when we should not act on it. We might, therefore, still have a moral reason not to speak falsely, even in a case where we must do so. To put it in terminology taken not from Kant, but from Bernard Williams, what Kant holds is that there is a moral cost to speaking falsely, even when we must speak falsely. This is why Kant says that even in such a case, we should not refuse the harsh name lie to a falsehood. For we do say such things as this: I wish I had not had to lie to him in order to avoid insulting him, in order to not to have the revealed confidential information, or in order to prevent this or that harm. Therefore, we cannot refuse the harsh name lie, even to some falsehoods we have to tell. The use of this harsh term, lie, marks the fact that there remains an overridden obligating reason to tell the truth, even when there is a stronger obligating reason not to speak truthfully. Now let's look more closely at the dispute between Kant and Benjamin Constant. This dispute was encouraged, perhaps even arranged, by Carl Friedrich Kramer, editor of Frankreich, a journal devoted to presenting French ideas to German philosophers. I think we must say that Karma did not do a good job of facilitating clear communication and mutual understanding between Constant and Kant. The obfuscation may even have been in part intentional. Kramer's own status in the scholarly world was plainly enhanced by being the go between in a controversy between two prominent philosophers, both well known for their liberal ideas. He may also have been motivated to make the French philosopher look better than the German one. Kramer was such a passionate advocate of the ideals of the French Revolution that in 1794 he was declared a dangerous political subversive, dismissed from his professorship at the University of Kiel, and expelled from the Duchy of Holstein, then under Danish rule. Kramer's mediation of the exchange between Constant and Kant in 1797 was evidently part of a promotion of French ideas in Germany, as well as his futile efforts at self-rehabilitation. So it's hard for me to condemn him too harshly for obfuscating things, despite the harm it has done to the understanding of Kant's ethics. The position Constant defends is that it is a generally valid ethical principle that it is wrong to lie, to speak falsely to others, but that there are exceptions. According to Constant, we have a right to speak falsely whenever the person to whom we speak does not have a right to the truth. Sometimes people are not entitled to know certain things, and if the only way we can keep this information from them is to speak falsely to them, then we have a right to do that. Constant sees his example of the murderer at the door as a self-evident illustration of this. Moreover, some of the literature defending Constant points out that during the French Revolution, it was sometimes necessary to conceal or falsify your political views or activities or those of your friends in order to save yourself or others from the guillotine. Clearly, Constant's case is compelling. And as we have already seen, Kant even says things that are in substantive agreement with it. So why does Kant's brief essay on the right to lie dispute Constant's principle? And precisely where does he disagree? One area of disagreement between Kant and Constant is in the relation of ethics to right or justice. In the right to lie essay, Kant emphasizes that the issue he means to discuss is about right, not about ethics. Constant takes the position, pretty familiar to us, I think, that matters of right are simply a special case of ethical principles when they are applied to politics and the law. In relation to the duty of veracity, Constant thinks that you generally have a duty, a moral duty, ethical duty, to tell the truth to people, but a right to withhold it or even falsify it in cases where the person has no right to it. Kant, by contrast, takes the foundations of right to be separate from those of ethics. Ethics is about rational self-government and self-constraint, promoting the ends of your own perfection and the happiness of others. Right, however, is not based on any ethical principle, but only on the fundamental right to freedom, independence of constraint by the will of another, subject only to the limitation that your freedom be consistent with that of all others according to universal law. Pure or strict right, Kant says, is not a matter of duty, but only of rightful coercion. But right and ethics can be joined in the larger systems of morals, morale, Sitte, when right borrows from ethics the ethical concept, but not the ethical principle. of duty or obligation. This borrowing makes possible duties or obligations of right as well as rightful coercion. All duties of right, moreover, are also indirectly ethical duties. Even in cases where you cannot be coerced to fulfill a duty of right, you still have an ethical duty to do it. This difference between Kant and Constant, however, does not fully explain why Kant would disagree with Constant's sensible sounding principle that we have a right to falsify what we say to someone who has no right to the truth, such as the would-be murderer in Constant's example. As we've seen, Kant could even seem to agree with that principle, since he says that if I can avert a truly great evil only by telling an untruth, then I may do so. The reason Kant resists Constant's principle is that he thinks there is an exception to it in the case of what Kant calls a declaration, declaratio, Deklaration, Aussage. A declaration, in the technical juridical sense, is a statement that, as a matter of right, must be truthful to the best of the speaker's knowledge. If a declaration is knowingly false, then the speaker commits a wrong or injustice and is guilty of a lie, lüge, mendatio, falsiloquium dolosum. And Kant insists, contrary to Constant's principle, that this holds even in cases where the person to whom the falsehood is told does not have a right to the truth. This is because a lying declaration, even when it does not wrong the person to whom it is made, nevertheless wrongs humanity in general, or the condition of right itself. Declarations are a chief source of right, since they permit us to rely on the word of others in ways that safeguard our external freedom. Two cases of declarations in this technical juridical sense are, first, testimony under oath in a court of law, and second, warranties offered in a contract. The latter case, as we've seen, as we will see in a moment, is explicitly mentioned in Kant's Right to Lie essay. And the former case is stated in the Critique of Practical Reason, where Kant says, "For it cannot hold with the universality of law that declarations, Aussagen, should be allowed as proof and yet be intentionally untrue." Kant's argument here is based on an important but overlooked concept in his moral philosophy, that of general injustice. Wrongs, injustices, are typically particular wrongs, done both by and to assignable individuals. If I assault you or steal from you, I do you a particular wrong or injustice. But Kant thinks there is an entire social system, such as custom or the market, that can treat people unjustly by depriving them of rightful freedom. This is what Kant calls a general injustice. Kant regards poverty in society as a general injustice. He thinks that it's the duty of the state to rectify general injustices. Kant holds that individual agents, too, can commit a general injustice. That is, they may wrong the condition of right as a whole or humanity at large, even without wronging any assignable individual. If I lie on the witness stand in a court of law, or if I lie in what I swear to as the terms of a contract, then I commit a general injustice. Even if the attorney who asks me the question in court did not have a right to know the answer, I would still owe it to humanity at large and the system of justice to testify truthfully in response to this question. Here, Kant disagrees with most jurists of his time. who do not recognize general injustices and think that a wrong occurs only when one assignable individual does a wrong to another one, which harms another assignable individual. With this in mind, let's look at the crucial passage from the Right to Lie essay, which I put on your handout, but now I will read it. This is the fullness in declarations, Aussagen, that one cannot avoid, is a human being's duty to everyone, however great the disadvantage to him or another that may result from the declaration. And although I may do wrong to him who unjustly compels me to make the declaration if I falsify it, I nevertheless do wrong in the most essential part of my duty in general by such a falsification, which can therefore be called a lie, although not in the jurist sense. That is, I bring it about as far as I can that declarations, Aussagen, Deklarationen, in general are not believed, and so too that all rights which are based on contracts come to nothing and lose their force. And this is a wrong inflicted on humanity generally. Thus, a lie defined merely as an intentional untrue declaration, Deklaration, to another, does not require what jurists insist upon for their definition, that it must harm another. Mendatium est falsiloquum in prejudicium alterius, for it always harms another, even if not another individual, nevertheless humanity generally, insomuch as it makes the source of right unusable. It is seldom appreciated that in this passage, Kant, from the Right to Lie essay, Kant is using terms lie and declaration in their technical juridical senses. He agrees with Constant, as we've already seen, that in most cases you may speak falsely to a person who has no right to the truth, such as a person who intends to use the information to commit a murder. But Kant wants to ask this question: what if the person is nevertheless in a position to require from you a declaration? In that case, Kant's position is that even if this individual has no right to the truth, it still holds that humanity in general, or the system of justice, has a right to your truthfulness, to the truth from you to the best of your knowledge, even if your truthful declaration harms an innocent person. You still must speak truthfully if your statement is a declaration in the juridical sense. In the Right to Lie essay, Kant never directly addresses the example of the murderer at the door. He is plainly not concerned with that example. When readers take what he says only to be weighing in with an insane position on Constant's example, they are imposing a hostile misreading on what he said. Kant does relate what he says to this example by considering what consequences may be imputed to you. He says that if you are required to give a declaration, then it is not up to you to withhold the information and you must not lie. In that case, what someone else does with the information you are required to give cannot be imputed to you as your deed. You cannot be held responsible for what others might do with that information. Therefore, suppose, hoping to protect the murderer's intended victim, you give a lying declaration about the victim's location. But unbeknownst to you, the victim has fled to the very place you say he is, and your lie thereby enables the murderer to kill him. In this case, Kant says, even if you intended your lie to thwart the crime, you are now to blame as an accomplice to the murder. We may still ask why Kant assumes the statement whose truthfulness at issue in the dispute with Constant to be a declaration in the juridical sense. That is hardly a natural assumption about what you might say to someone who just shows up at your door, especially someone with murderous intent. One obvious thing to say is that Kant is simply not interested in Constant's example of the murderer at the door. He is interested in the general principle to which Constant is appealing, namely, that you have a right to falsify your statement to anyone who has no right to the truth. Given Kant's disagreement with the jurists who fail to acknowledge general injustice, he may merely want to insist that Constant's principle is subject to this exception. It is ironic that Kant is usually understood to be irrationally inflexible, recognizing no exceptions to moral principles, when in fact his concern is precisely to emphasize the exception to the principle about lying to which Constant is appealing. Another possible explanation, however, comes from the fact that the title of Constant's essay was Des réactions politiques. It is one of Kant's own important principles, emphasized in his appendix to Perpetual Peace, that statesmen and politicians have a duty of right to be truthful in their public utterances, and they wrong the public, even humanity at large, if they lie in their official pronouncements. Kant seems to regard public statements as by politicians as declarations in the juridical sense. So if politics is the topic of the discussion Karma has instituted between himself and Constant, then Kant could think it is reasonable to take the issue of veracity as those of which we should apply the juridical concept of a declaration. That Constant chose an example of the murderer at the door is not a natural one to which to apply the juridical concept of a declaration, might have been thought by Kant to be simply beside the point. And if he did think that, he would be right. I think Kant's position in the Right to Lie essay is very far from what is usually attributed to him. But the position I'm describing to Kant is both supported by his own statements and makes far more sense than was the Right to Lie essay itself, as it is often is read. But even if we read Kant the way I'm proposing, we might still have qualms about his position, for it places great moral weight on the notion of a declaration in the juridical sense. Suppose I'm a witness testifying in a court on a capital case. Suppose I know the accused to be innocent of the crime, but I'm prevented by the rules of evidence from proving it at the trial. Suppose further that the prosecutor knows the truth but still wants the accused to be convicted and executed. And suppose he asks me a question, the truthful answer to which I know will result in a conviction. Kant's position would require me to answer truthfully and accept that result, which is substantively unjust and even terrible. As I've described the example, it would be closely parallel to that of the murderer at the door, and Kant's position, based on his strong views about the wrongfulness of a false declaration, would seem to commit him to a position disturbingly similar to the one commonly attributed to him. Many will surely be tempted to say that I should lie on the witness stand so as to achieve a substantially just result. Henry Sidgwick thought that a witness who truly values veracity would tell the lie that turns out to be necessary for the truth to prevail in a court of law. But to this, a defender of Kant's position might reply that to do that would be not to fulfill my duty in the role of witness, but to arrogate myself the role of both judge and jury. If witnesses were permitted to lie whenever they could thereby secure the outcome they preferred, they would defeat the purpose of the entire process of justice. In one sense of the term, consequentialism is the position that we should always try to act in whatever way procures for us whatever we consider to be the best immediate result. As a matter of history, this is, in fact, the original sense of the term consequentialism when it was first introduced into our philosophical vocabulary by Elizabeth Anscombe back in 1958. Anscombe held that consequentialism in this sense is not merely short-sighted, but profoundly immoral. As she put it, it exhibits a corrupt mind. Most philosophers who now call themselves consequentialists would be willing to accept a bad result in some cases for the sake of preserving arrangements that people could be seen to be a more long-term benefit because they preserve trust between people. They know we would all be worse off in the long run if we habitually broke promises for the sake of immediate gain or lied whenever we found it expedient. These observations suggest to me that Kant's position on the right to lie essay could even be given a strong consequentialist defense, as long as consequentialism is given a more sympathetic interpretation than the one Anscombe gave it. In order to achieve important social ends, such as legal justice, we establish certain procedures we considered fair and which balance different factors. For instance, we require truthfulness in court, whatever the immediate consequences. However, cases do arise where following these procedures fails to achieve the end we seek, and even results in the very opposite of their intended purpose. Truthful testimony in court could result in a guilty person going free or an innocent person being convicted. When this happens, it is painful, sometimes even tragic. We may wish that we could somehow avoid the terrible result, even if we must act contrary to the rules of the procedure, as by lying on the witness stand. But that wish is not only short-sighted, but also dangerous. Here Kant agrees with John Stuart Mill, who holds that while it may be expedient in some individual case to tell a lie in order to avoid an undesirable result, observing the rule that we must tell the truth is expedient in a much higher degree. Those are Mill's words. There may still be extreme cases where we think the damage done to the procedure is outweighed by the need to avoid the disastrous consequence of following it. But the hard truth is that if we permitted this way of thinking, which is consequentialism in Anscombe's original negative sense, to become a general policy, then Mill as well as Kant, for both Mill as well as Kant, it would, in Kant's own words, make any society impossible. Thank you.